Okay, this is our first main class session that we are having this semester. We're going to start with Introduction to American Contract Law, okay? Because yes, the main law that you will operate in will be Korean law. But if you're going to be dealing with the international business contracts, you will be using those Korean concepts, Korean legal concepts in English. So you need to have some body of law that uses English a lot. That's American law. So, of course, a lot of legal concepts in Korean law are different from the ones in American law. So what we'll have to do is we'll just have to find the closest approximations to the Korean legal concepts and use those approximations as translations of Korean legal concepts. Okay? And you will want to know, and you will also want to know the relations between all these approximations. You'll also want to learn American law as a whole, so that you understand how a Korean legal concept is similar to or different from American legal concept. Okay? Now, how many of you studied Korean contract law? All right, all three of you. You have not?
No.
Okay, all right, it's okay. It's okay. You can start learning contract law from any country. Okay. All right. Contract law is probably the heaviest course in the first year law school in the United States. Usually takes 4 to 5 hours a week for 15 weeks. We're going to try to do this in 3 hours today. Okay? All right. What you see is the schedule that summarizes American contract law and probably the most important concepts. Okay, when I say something loud, that's my request for you to repeat after me. Okay? Formation. I said repeat, okay? And repeat loudly. Formation.
Formation.
Okay. To form a contract, you need 3 elements, 3 requirements. First, offer and acceptance. That was loud. Okay. Capacity.
Capacity.
Consideration.
Consideration.
Okay. Formation means 계약의 성립이죠. Offer and acceptance. What would be the Korean translation of that? Anyone? Good. Capacity. Capacity. It is the legal capacity, 능력이죠, 능력. So there are people who don't have capacities to enter into contract. Who are they? Minors. And? Yes. And sometimes people in prison. Okay. Consideration is the most frequently mistranslated word. Consideration doesn't mean thinking about something. Consideration doesn't mean making accommodation for other people's concerns. Consideration means bargain. So in Korean, the best translation will be 대가, right? So consideration is often translated into things like 배려 or 고려. That's all wrong translations. It means 대가. So for one contract to come into form, you need all three elements to be met. All right? Okay. Now, after a contract is formed, if it's performed, then there is no need to see a lawyer. There is no legal issue. Okay? People who have performed contracts will not come to you. All right? Performance. What would be the translation of that? 이행. Good. All right? 계약이 이행되면은 여러분들 만날 필요가 없죠, 이제. But what if not? Okay? Now there are three situations. There are three situations that you fall into if a contract is not performed. Okay? Well, the most famous and the most undesired situation you want to be in is a contract is breached. Okay? So here contract is not performed, right? But there are times that contract is not performed, and yet it's not a breach. Okay? There are two situations like that. One is when condition for a contract is not satisfied. 조건이죠, 조건. 그래서 선행 조건이 있을 수 있고 후행 조건이 있을 수 있는데 그 관련된 말들은 제가 좀 이따 말씀드릴게요. 그래서 계약의 선행 조건이나 후행 조건이 if it's not satisfied, then and it's not performed, it's okay. It's not breached. And then the second time the contract is not performed and yet is not called a breach is when contract is discharged. Discharge는 뭐랄까 그 면책이라고 볼 수 있죠. 그 계약을 이행할 책임으로부터 해방됐다. 이런 취지로. And I'll tell you the examples of discharge soon. Okay. Now, if a contract is breached, so condition, discharge, breach are not elements of performance. Okay. These three things are what's not performance. Okay. All right. Now, if a contract is breached, okay. Now, if contract is performed, no problem. If contract's condition is not satisfied, therefore contract is no longer void, no problem. If contract is discharged, no problem. But if contract is breached, now we still need to see lawyers, and you see them for the question of remedies. Repeat after me. Remedies. 구제책이라고 보시면 됩니다. And then there are three types of remedies. Termination. Okay. Termination. 계약의 종료. 계약의 종료. 다른 뜻도 있는데 그러니까 termination에 해당한 다른 우리말도 있는데 그건 좀 이따 말씀드리고 우선 계약의 종료. 계약을 이제 종식시킬 수가 있는 겁니다. But whose remedy is this? Whose remedy? The breaching party or non-breaching party? 계약을 자, breach가 뭔지는 설명. Breach. What do you call breach in Korean? 채무불이행. Okay. But that's for lawyers. Ordinary people. What do they call breach? 위반. 계약 파기 이런 말 쓰는데 파기라는 건 원래 없는 거죠. 법적으로 아무 계약 파기가 뭔지는 뭐 좀 이따 설명드리고 여튼 법적으로는 별 의미가 없는 말이죠. 위반. So this is for a non-breaching party. Okay? This non-breaching party's remedies. He can terminate a contract, right? Or he can seek damages. Repeat after me. Damages. 손해란 뜻으로도 쓰이지만 손해배상이란 뜻으로 변호사들 사이에서는 더 많이 쓰이죠. So it has two meanings, both damage itself and compensation for damages. Okay. The third is injunctive relief. relief는 remedies랑 같은 말이에요. 네, 구제책이라는 뜻이고 injunctive relief, injunctive는 뭐의 형용사형이냐면 enjoin. enjoin. Okay, it's not enjoy. Okay, it'll be more fun, but it's not enjoy. It's enjoin. Enjoin means order someone to do something. Order. Usually, order someone not to do something is enjoin. So, when people say, "Oh, I'm enjoined," means I'm prohibited by court from doing something, right? So, enjoin adjective form is injunctive relief. So, injunctive relief means 뭐 우리말로 치자면 명령적인 구제 이렇게 볼 수 있죠. Right. Next, before we go further, let's look at some terms. Okay. Words. Okay. Words. Phrases. Clauses. Sentences. Subparagraphs. Paragraphs. Sections. Articles. Chapter. Okay. So you can see it is in the order of larger units of a text, right? The words is the smallest unit. Words add up to become phrases, which add up to become clauses, which add up to become sentences, and sentences add up to become subparagraphs. And starting from subparagraphs, one subparagraph can be a provision, right? 하나의 조항이라고 부를 때. One provision. And subparagraphs can add up to paragraphs. Also, one paragraph can be a provision. So paragraph 1, let's look at paragraph 24, let's look at paragraph 14, blah, 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 right? Paragraphs add up to sections, sections add up to articles, articles add up to chapter. So subparagraphs, from subparagraphs to articles are the names that drafters, contract drafters give to various provisions in the contract. Okay. Now you usually don't call a sentence a provision. 그냥 문장일 뿐이죠. 하나의 조항이라고 부르진 않죠. 물론 이제 문장 하나가 it's possible one sentence can form one provision, but you know you don't call like sentence 12 of a contract, right? All right. Why are we learning this? Because when you negotiate a contract with the other side, it's very important. It's very useful for you to point out. Please look at the second sentence, or look at the second phrase of subparagraph 12. Okay? Instead of writing out the whole thing, you can just point the other side to, look at the second phrase of subparagraph 12. Isn't it odd that you are requiring exclusivity? Okay? Or you can say, I object to the first clause of Article 15, but I accept all other clauses. Okay? You want to be able to say those things through email or through verbal negotiation to save time. Okay? Instead of reading out, I object to A shall transport the objects A through Z, right? Instead of reading the whole thing, you want to be able to pinpoint what you object or what you accept. Okay. More terms. Okay. Before we go further, who knows the difference between phrase and clause? Okay, what's the difference between 구 and 절? Which one is 구, which one is 절? Okay. All right, what's the difference? 그건 여기 보면 알잖아. 예.
Yes, clause is comprised of the subject and verb
Good.
with the punctuation mark at the end of that. But
Okay.
phrase is just chunk of words.
Okay.
That's
Okay.
the kind of difference.
Okay. But many clauses don't end with the punctuation marks. Okay. So one clause always has, as he said, subject and verb, right? So if you just take out a clause, it can form a full sentence, right? Okay, life of a contract. Repeat after me. Life of a contract. Execution. Okay, what does execution mean? It's not execution. Okay, it's execution, right? Execution can have several different meanings. Execution can mean death penalty. Okay. Execution mean performing something, right? Performing some task that you are given. Execution could also mean signing something. Okay. So legally, when you execute a document, that means you signed it. So there are usually sentences like execute a will. What's a will? 유언장. Okay. And you can execute a check. 수표. Right? So when you see execution, don't ever think of performance. Okay? Execution in contract law means signing something. Now, execution, now entry. Repeat after me. Entry. Okay. Signing. Right. Usually, entering into a contract is triggered by signing or execution. Right. So you can say it's a one event. Comes after that is effective date. Repeat after me. Effective date. So this is when a contract becomes effective. Okay. Now notice that execution, effective date is not necessarily the same as the date of execution or entry or signing. Okay? I'll talk about when a contract becomes effective at a later date than the signing date. Okay? I'll talk about that soon. When contract becomes effective, now you can say it is formed, formation. Okay, no, let me see. Formation. Yes, let's say it has formed. It has formed on effective date. Is that right? Formation, execution, entry, signing, effective date. I think, all right, let's revise this. When a contract is executed, entered into, or signed, if these three elements, offer and acceptance capacity consideration, if all the three elements are met, then contract is formed. So can you please take this out, take out formation, and put it right here. Okay? But effective date comes later. Effective date can come after formation. I'll change it for you. And after it has become effective, it can be performed. Now, if it's not performed, it can end in different ways. Now, all three forms of ending a contract can be categorized under this term, termination. Okay? Termination with a big T. And it has three different types of terminating a contract. Repeat after me. Termination. Expiration. Cancellation. Okay. Cancellation is also called, rescission. Repeat after me, rescission. Okay. Cancellation, rescission is almost the same thing, and it usually means returning to the pre-signing status. Okay. Returning the parties to the pre-signing status. So give me an example of when you cancel a contract or when you rescind a contract so that you are returned to the pre-signing or pre-execution status. You studied Korean contract law. When does that happen? In case of fraud. Okay, good. So 사기 상황에서는 계약을 어떻게 해요? So what would be the good translation of cancellation or rescission? Cancellation or rescission. What would be good Korean translation? I'm asking you.
Between cancellation and rescission.
No. What would be the... we are treating cancellation and rescission as the same thing here.
Yes.
And what would be, so under Korean law, what do you do when you cancel a contract that's the result of a fraud? What do you call that in Korean? 취소. 취소, okay. Is there any other term? 해제, good. All right. So cancellation rescission is like 해제. Okay. But then again, there are many scholars who think that there is still difference between rescission cancellation on one hand and 취소 and 해제 on the other. But roughly, I think they overlap in the sense that both concepts bring the parties to a situation where they've never met, right? Where as if they never signed the contract. Okay? So you call that cancellation or rescission. Now termination is a different thing. So termination is here. Termination is an artificial ending of the contract. Okay? Ending of the contract. So it takes a party's decision, a party's conscious decision to end the contract. We call that termination. Now that termination, this termination has two kinds. Repeat after me. Termination for cause. 이건 이제 이유가 있어서 해지하는 거죠. 제가 또 질문으로 할 걸 또 말을 해버렸는데 해지라고 해지에 해당하는 말인 것 같아요. termination은. So it's a ending of a contract, fully giving credit to the existence of the contract. Okay? You are not returning the parties to a time where they never met, right? You give full credit to the contract, and you treat each party as if they have entered into contract and terminate the contract. So if there is a money due, right, then they have to pay each other. If there are things that you are supposed to deliver but did not deliver, you have to do something in return. You have to do something instead, like pay money or do something. Okay? You cannot ignore the fact that the contract existed under the termination situation. Okay? And there is a termination at will. Repeat after me. Termination at will. You also can terminate a contract by conscious act at will, okay? Without any cause. What would be the most important reason what would be the most important cause for terminating a contract? When the other side has breached. Okay? That would be a termination for a cause. But there are times that you want to terminate. You may be able to terminate even if the other side has not breached. If there is a clause, if there is a provision authorizing you, allowing you to terminate at will. Okay? Remember, I'm not, don't make any mistake. I'm not telling you any rules. I'm just letting you know these terms, how to use those terms. Expiration. What is expiration? Natural death of a contract. Okay, if a contract has 10-year terms, and when the contract hits the 10-year mark, it disappears. Okay? So there are, you can see, 3 different ways of calling a contract dying. Okay? And you want to use the correct term when you negotiate with the other side. Okay? Are you talking about cancellation? Are you talking about returning the parties to the pre-signing stage? Or are you talking about ending the contract while giving full credit to the existence of the contract? Okay? Settling all the accounts. Settling accounts. 정산이라는 표현을 많이 쓰죠, 우리나라에선. 계약에 따른 정산을 다 할 것을 예상을 하고 다 할 것을 그 조건으로 계약을 종식시키려면 termination을 해야 되겠죠. Okay. Question, comment so far. Okay. Next. So we're going to go through each item on this schedule. Okay. Formation, offer and acceptance. Repeat after me. Mirror rule. Okay, mirror rule. What is the mirror rule? That means offer and acceptance has to be exactly the same as if one is the mirror image of the other. Okay? Only then a contract is properly considered to be accepted. Okay? That's the basic rule. Now, different laws have been created to soften this rule, okay, whereby sometimes a contract is a little bit different, but only by minor points, is often considered acceptance of a contract, right? But then a lot of times when you work with a contract, when you, as a lawyer, when you work, you usually have to follow the mirror rule because almost all your contracts will say that we'll have the signature lines on one document. So you are signing the same document, which means that there are no 2 separate documents that have to be equal. There's just one document. Okay? So you just end up signing, both parties end up signing one document. So mirror rule is almost automatically satisfied. Now, one frequently asked question is, one frequently asked question that I got was, so my client has negotiated with the other side for over 6 months through email, right? And then he thinks the parties have finally come to an agreement. So he told the other side to sign the contract and send it over. Signed, came through courier, looked at it. It's a 100-page document. He likes everything except one comma. Okay. So he asks, hey, he asks me, I'm a lawyer, oh, it's 100%, it's 99.9% congruent, agreeable to me, except this one comma. I have to take it out. Since the contract came in with a comma, can I just white it out? Can I just erase it and then sign at the bottom and then just send it back? Would that be a valid acceptance? Would that be a valid acceptance? Well, I already gave out the hints. No. Okay. It might be a comma for you, but it might be a world of difference for the other side who sent in the contract. If I just change one item in the contract, the other side may say, hey, if you are going to change that, we would have asked for this other thing, that other thing, right? If you're going to take out that comma, I would have proposed whole other paragraph. Okay? You never know, right? So you have to comply with mirror rule when you are working as a lawyer and dealing with a long business contract that has signature pages for both parties. Okay? Now there are times, this has really happened, and this may happen sometimes. What if each side signs his or her own copy, but not on the same document? For instance, I signed something and sent it over. The other side, and then of course I made a copy and I'm keeping it. And I sent in the original to the other side. The other side signs the same document, and just because of poor communication, they also signed their side and sent it over, and they kept a copy. Two documents are exactly the same. Is that a valid offer and acceptance? What do you think? Yes? No? Okay. Why?
I think it's just a matter of communication, not.
Okay. So what's the most important thing in the formation of contract?
Meeting of mind.
Good. Meeting of minds. Right? What do you call that in Korean law? Good. Right? Because if there is an evidence that there is 의사의 합치, then that's sufficient. Okay. Repeat after me, pronouncing these terms. Purchase order. Pro forma invoice. Offer sheet. These are the documents that are often used to offer or accept a contract, right? So, well, when it involves sale and purchase agreement, 매매계약서에서 청약과 승낙을 발생시키는 문서들의 이름. But name doesn't matter. Okay? Offer and acceptance can take place without any document that has a name. Right? You can offer with a purchase order, and the other side can accept with an offer sheet. You can offer with a pro forma invoice. Okay? It's a pro forma because invoice is something that you get after you got your goods, right? Right? But pro forma invoice is something like, hey, if you accept this, this is what you will be. This is what you will be paying, right? That's pro forma invoice. So you can offer with a pro forma invoice, and you can accept with a purchase order, and the other way around. Okay? Name doesn't matter. Finally, consideration. Repeat after me. Consideration. Okay. Probably this is what's most prominently different between Korean contract law and American contract law. And usually it's a non-issue for you lawyers because people without contract, people with the contracts without consideration will never come to you. But then again, if you represent NGOs that accept charities, gifts, then you may run into issues on consideration. There is an American legal maxim, 경구죠, maxim. There is no gift contract. Repeat after me. There is no gift contract.
There is no gift contract.
Okay. Gift contract means contract without consideration. Contract without consideration is void. Okay. So if I offer, your name was Hijin. If I offer Hijin, if I offer Hijin after I turn off my phone, if I offer Hijin, well, if I offer to give Hijin $1 million on January 1st, 2015, and what would you do if I make that offer in writing? You'll accept it. All right. How would you accept it?
I will sign.
Okay, you will countersign. Countersign means 서명된 거 반대쪽에 서명하는 countersign이라고 합니다. So it's countersign. That contract will be immediately void. Okay? Even if it's properly offered and accepted, and we are both adults with proper capacity to enter into a contract, it becomes void. I don't know why. I think that there is a very complicated history of a common law precedents. But what I learned is that consideration is really important. I'm sure some of your civil law professors, Korean civil law professors, have intricate details about why Anglo-American law has come to require consideration as the requirement, as the element of a valid contract. Okay? But there is this other thing called promissory estoppel. Repeat after me. Promissory estoppel. 에스토펄은 이제 우리나라에서는 금반원 뭐 이렇게 번역이 되는 것 같아요. So it's not a fraud. It's not a fraud, but you lead somebody to do something, okay, and thereby cause damages. Okay? So that's not really a contract. That's not really a contract. It is a tort. tort는 민사불법행위죠. Okay. So if I made you do something, if I caused you damages by making you enter into this invalid contract of giving you $1 million, then I don't have a duty to give you $1 million because it's not a contract, but I have a duty to compensate you for any damage you suffered because you relied on my contract. So for instance, let's say as I was offering $1 million on January 1st next year, you clearly let me know that you are going to use $1 million to build, I don't know, a church, a new church building by borrowing $1 million from a bank, and then hiring a contractor on $2 million job, right? Let's say as I was promising you $1 million, you were entering into these two other contracts. One loan contract with the bank, the other construction contract with a contractor. And now January 1st comes and the money, my money is not coming. Now you know that the contract is void. If I knew that you are relying on my promise, and then you suffer damages because of the two contracts that you entered into, then I may be liable to you for the damages you suffered in getting out of those two contracts. Okay? For instance, you'll have to pay bank some penalties, and the contractors also some penalties, right? That's promissory estoppel. Whether the estopped party, or not the estopped party, whether the damaged party has a valid cause of action. Cause of action은 문자 그대로 청구 원인이죠. 청구 원인. Whether the damaged party has a valid cause of action will depend on whether the reliance was reasonable. Okay? Whether you're relying on my promise was reasonable. Okay? All right, any question, comment on promissory estoppel? No? All right. Capacity. Repeat after me. Capacity. Capacity of both offeror and offeree has to be there for a contract to be valid. Okay. Now, usually, capacity question in international business contract arises out of these questions of express authority, implied authority, and apparent authority. Okay. Because you are usually dealing with a business association, like a corporation or limited liability company. Okay. Corporation, what is a corporation in Korean? 법인. Corporation, corp, body란 뜻이 body. 어떤 뭔가를 체화했다. 뭔가를 법적으로 사람인 것처럼 이렇게 만들었다. 그래서 corporation이라고 부르고. There are several forms of corporations. One is 주식회사. And I think Kim Han-jang has the habit of translating that into stock company, 주식회사, stock company. The other form of corporation, limited liability company. Okay, limited liability company. 유한회사죠. And then there is a partnership. Okay. And there is a sole proprietor. Okay. These are all different forms of business association. Now, when you make an offer, a corporation does not make an offer. A person on behalf of a corporation makes an offer. So always there is a question of whether the person making the offer or accepting the offer has the authority to represent the corporation. Now, one question I got a lot when I was a lawyer was, okay, so both sides negotiated a contract over a long time. Now they want to have a signing ceremony, say in Where's your favorite place that you want to go?
Very place.
Yeah, for sightseeing.
Namsan.
Huh?
Namsan.
Namsan? I was thinking of Paris or something, but okay.
Paris.
Okay, all right, you want to go to Paris. All right. So you have to meet in Paris. So the Korean company, your client, calls you all worried and saying, oh, our CEO doesn't have time to go there. Our manager doesn't have time to go there. Our lieutenant manager, Daddy, lieutenant manager doesn't have time to go there. Only, it's 말단. I don't know the term for 말단. This lowest level employee has time to go sign. Is it okay for us to just send in, I don't know, say our secretary to go sign our contract? It's a $1 billion contract. Can we still send somebody as low level as a secretary? By the way, secretary is not always a low level employee, right? Secretary General, they are, or Secretary of the Board are the highest level officers, but I'm talking about real secretary, okay? Is that okay? Is a contract signed by a secretary of a corporation valid? You learned your Korean contract law. See, you are relearning Korean contract law just in a new language, that's all. Same thing.
Yes, it could be valid if the CEO gave the authority.
Okay, good. That's express authority. As long as there is express authority, does she need to take a power of attorney with her? Power of attorney means 위임장이죠. 네. Power of attorney를 변호사의 힘이라고 번역한 걸 실제로 봤어요, 제가 한번. 많이 안 웃네. Anyway, does she need to take power of attorney with her? No. Okay. As long as there was truthful delegation, 위임이죠, 위임. Truthful delegation. That was properly expressed. Doesn't need to be in writing. Okay. Now, that doesn't mean that the other side will accept your secretary as the proper offerer or offeree. That doesn't mean that. Okay. So I'm going to talk about, let's say, let's ask yourself, let's say you are signing $1 billion contract and the other side sent a secretary. How would you respond? How would you respond? What do you need to think about? Well, you need to think about whether she has express authority, right? But how would you prove that? I mean, how would you know that she has express authority?
I would require the counterpart to give me a written
Power of attorney, right?
attorney.
But the power of attorney, let's say she produces, 제출한다는 얘기죠. She produces power of attorney and has a signature. How do you know that is something that's not forged? Call the CEO, okay? The number for the CEO is printed on the power of attorney. You call that number, how can you be sure that that number is the company's phone number? How would you know that the person answering the phone is actually the CEO? Okay. So you want to make sure, as you are signing a contract, you want to make sure that the other side has, repeat after me, apparent authority. Apparent authority has the power to force the other side, force liability on the other side. 상대방한테 책임을 전가할 수 있는 그런 힘을 가진 게 that's apparent authority. Okay. So this is a real case, right? I represented a film producer in Korea. I'm sorry, film distributor in Korea. Okay. So what this company does is buys films from within Korea and outside Korea, and then shows them in movie theaters. Okay. Now the company doesn't wants to get as many good American movies as possible because American movies are popular. You know that 85% of all the silver screens around the world are showing always American movies. Okay, 85%. So he, but you know, when good American movies come out, you have to live in the U.S. to get the first cut, because let's say good movie came out. Usually, you want the exclusive right. You want the exclusive right to show that in Korea. Okay. All the distributors want the exclusive rights because I can talk about this later when I talk about distributorship agreement. But all distributors want the exclusivity because if they want to do good sales, they want to invest in advertising and publicity, or publicity and advertising. We call that P&A. Publicity and advertising. Now, when you invest in publicity and as a distributor, when you invest in publicity and advertising, you don't want other people to get a free ride on that. Okay. If the more advertising you spend on, the more, all the benefits of advertising and publicity, you want to reap the benefits. You want to reap them. You don't want some other company selling the same stuff to benefit from the advertising money that you spent. Okay. So you want the exclusivity. Now, to get the exclusivity, you have to be there in the U.S. when the movie producers, they usually do a tour. They usually have a showcase of this year's movies, right? And you want to be there and then be the first one to sign that movie. This company doesn't have the money to hire somebody who lives in the U.S., so finds a nice person who already lives in the U.S., and then makes him a name card that says Vice President. Let's just assume that his name is John Kim. And let's say the company's name is Korea Pictures. Okay. And let him, and then Korea Pictures let him make the deals in the U.S. using these name cards. So he signs a contract, and when the contract comes in, the Korean company, the Korea Pictures, actually performs on those contracts. Okay, and he brought in some good movies a few times. Okay, so now he's known as Vice President of Korea Pictures, although really he is nothing. He has no relationship. He has no. He's not an employee of Korea Pictures. He just has, and of course, not vice president. Okay. But one day, he buys a movie for $1 million, without telling the Korean Pictures. Okay? And it's a movie that Korea Pictures didn't want. Now, is Korea Pictures responsible for paying the $1 million and getting the movie shown in Korea? Yes? No? Answer is yes. Even though he's nobody, even though John Kim is nobody in Korea Pictures, because Korea Pictures has made it, okay, look over here. Because Korea Pictures made it reasonable for a third party to rely upon John Kim's representations, okay, whatever John Kim was doing, he was doing on behalf of Korea Pictures. Although he was not talking to Korea Pictures at all. Although he was not representing, in reality, Korea Pictures was not representing, in reality, John Kim was not representing Korea Pictures, but under the law, Korea Pictures is responsible for all the contracts that John Kim has signed. Okay? That's apparent authority. All right? Now, let's go back to that $1 billion contract. When the other side sends a secretary over to sign the contract, you want to make sure that you get somebody like John Kim. Okay? You get somebody with apparent authority. Right? So that after that person signs, the other side is fully obligated under the contract. Okay? Right? So when you send your person, if there's express authority, that's fine. But when you look at the other side, when you receive the other side's representative, you want to make sure that the other side has apparent authority. Okay? apparent의 동사형이 appear. 그래서 이제 apparent authority는 우리말로 뭐라고 하죠? 표현대리. 나타나 보이는 appear. 그래서 apparent authority라고 합니다. Or quick and I mean, it's not just it's not just because you want foolproof representation like John Kim's, but also if you think the contract if you find the contract so valuable to you, you want to make sure that it doesn't become void because of a lack of authority, right? Because if the other side didn't have express authority, that means the contract is void. Because capacity is one of the three elements of formation. If either side has no authority, okay, if either side has no capacity, then the contract becomes void, right? If you want the contract, you want to make sure that both sides have the authority. So you want to make sure that the other side has express authority. But as I told you, it's difficult to find out whether the other side has express authority or not. Okay? Because power of attorney can be forged, the phone number there can be forged, the person's identity can be forged. Okay? And also, the other way of delegating power is, repeat after me, implied authority. Say, this desk is the property of 고려 학원. Okay, this desk. Do you think that 고려 학원 이사장 has signed a contract to buy this? No, right? Do you think that 고려학원 이사장 has given express authority to somebody to buy this desk? No. Right? But there must have been somebody within 고려학원 structure that has implied authority to buy this desk. Okay? So that's implied authority. That's easy, right? So in light of his ordinary duties and position, you may have the authority to do something on behalf of the corporation even when you are not expressly authorized to do it. Okay? But again, express authority and both implied authority are difficult to prove. Because, well, yes, it's difficult to prove on your employee, but on the other side's employee, you never know whether that other side's employee has express authority or implied authority. Okay? Because you don't know that secretary's ordinary job duties if she just shows up for the first time in front of you. Okay? So you want apparent authority. Okay? On the other side, quick quiz. All right, this is a technology transfer agreement. 기술 이전 계약서죠. Technology transfer agreement. The other side sent in a sales manager. Would you let the sales manager sign the contract? No. Okay? If it's a technology transfer agreement, of course, I mean, there is no law. There is no law says sales manager cannot sign technology transfer agreement. Okay? But just having worked in this setting often, I found that even a smaller venture company has sales department that's different from R&D department, and sales department usually has no knowledge and no authority over the technology that the company has. 그래서 이제 뭐 연구소장, 뭐 이사급 연구소장이나 꼭 이사급 아니더라도 누군가 이것에 대해서 apparent authority를 가지고 있다고 할 만한 사람을 서명자로 요구를 하는 것이 옳습니다. Okay, any question or comment about this? Again, it's okay to advise your client to send their secretaries as long as the other side accepts. Okay? But you must advise your client not to accept a secretary from the other side. Get it? Okay.